Alex here with a video on psychological evaluations. This is a question that I get a lot, and I feel like I've covered this in other videos, but when I took a closer look, I didn't. I have a video that covers evaluating mental health and all that stuff, but that's from the sense of your own perspective of what's going on in your case. It's not actually in the sense of being subjected to a psychological examination or having your ex subjected to one. And this is a legal nuts and bolts video because, believe it or not, it's not just a family court thing. There's rules of civil procedure that govern how this works in any kind of case. And I'm still going to do this video mostly from the family court perspective since that's most of my viewership. But just in case you're wondering, that's why I categorized it under a legal nuts and bolts video. So typically, the number one thing that jumps out as a problem for most people on this channel when it comes to psychological evaluations is money. A lot of people don't want to pay for it because they can't afford it, or because they can afford it but it'll break the bank and they'll be poor for a few months. My understanding is that there's this general rule that these judges have to take into account your income, your assets, and all of that, and they usually do that in the form of reviewing your financial disclosure form. My instinct, I'm just telling you guys, this is my instinct. You have to do your own research. My instinct would be that if you legitimately cannot possibly pay it, and then they say something like, we're going to, just assume the worst, which is an adverse inference, or you can't see your kids until you do one, you might potentially have some kind of basis to challenge that order. But off the top of my head, nothing jumps out at me. I see a lot of situations where people are ordered to go undergo a psychological evaluation and they don't. And the court, in family court, says, well, you just can't see your kids until you have one. And there's situations where people just haven't seen their kids for years because they don't want to do one. Or maybe they claim they can't afford them, but for whatever reason haven't challenged it on appeal or writ review. So the rules of civil procedure that I took a really quick look at, and I'm not going to go into the details because these change all the time. In fact, I could have sworn that when I was representing myself in 2008, these didn't exist. So I do see that there are rules of civil procedure now on child custody, physical mental examinations, and even evaluations of children, which I do think I have a video on that separately. But, at the time they didn't exist and they could change. The only thing that jumps out at me is, well, three things I was going to say. The first is costs. There's rules that determine how the costs are to be distributed. The second thing is recording, whether or not you can record it. And the third thing is observers, whether or not you can send an observer. And for the most part, these things seem to be discretionary and they vary on whether it's a child custody situation or it's just an ordinary money case. When it comes to recording, the only reason I think that would become relevant is possibly it's some kind of basis to make a record so that you can cite to it on appeal. That's the only reason I can think of that being an issue. I'm not really sure much about why observers would need to be there, except maybe that when you get to the trial, you can use the observer as a witness to maybe confront something that occurred. So these are just obvious things that jump out at me. But overall, that's all I have with regards to the procedure. I do remember there was an interesting case recently in Nevada where there was a law that conflicted with the court rule on observers and or recording, one or the other. And the conflict was actually not resolved in favor of the statute. It was resolved in favor of the court rule. Apparently, they treat these rules as procedural. And if it's a procedural rule, the court trumps the legislature. There's all kinds of nuances behind this as well. But I just wanted to let you guys know that was an interesting thing that actually got my attention to this too. So that's honestly the beginning and the end of custody evaluations in most of these high conflict cases. That's really all that there is to cover. Somebody gets ordered to undergo a psychological evaluation because they're doing really weird things. That particular somebody refuses to do so, and then they don't get to see their kids. Somebody was asking me, how can you force your ex to undergo a psychological evaluation? That's in the rules. As far as I've seen, there are ways to go about it. Typically, a motion, and then there's criteria that the court takes a look at. But like I said, I really am curious to see how these courts deal with situations where people can't afford it. Because there may be people that really need to be subjected to a psychological evaluation, but they are too poor to pay for one. And if neither party can pay for one, and it's not in the best interest of the child to continue to be with this particular parent, what's the court going to do? Because then there's this tricky situation where, okay, no custody for that parent, but is that because of the conduct, or is that because they aren't taking the eval? These things are problematic for an appellate court. because people shouldn't lose their kids because they're too poor. But at the same time, maybe the court makes a good record and says, here's all of the things that this person's doing that are abusive or neglectful, and that actually gets upheld on appeal. It's a tricky situation. So there isn't a silver bullet, really, to get out of a psychological evaluation, nor is there a silver bullet to force your ex to undergo one. There are rules of civil procedure in Nevada. Before these rules were in place, I really have no idea what you could do for yourself. A lot of times, to me, it felt like the Wild West. When I was representing myself in 2008, there weren't rules for all sorts of things that the courts were doing. And they did them anyway. And I'm not sure really what the position of the appellate courts was. I mean, there's obvious things that family court judges need to do: separate the assets out, visitation schedule, custodial designations, legal custody also, legal and physical custody both. But then there's other things that are not mentioned that include, I guess, subjecting people to psychological examinations. And there maybe was some kind of case law on it, or maybe they treated it as a discovery issue or something like that. But with family court, it often seems sometimes a little bit like a punishment. And especially when it was post-judgment, which you can't have discovery and post-judgment, but it's just not, it's really its own creature. So I'm kind of happy to see that these new rules came up, because they didn't exist at the time, and these rules seem to answer a lot of questions for me. It's on my left screen, that's why I look over there. But I don't know what else to tell you guys when it comes to this. This is a pretty common thing in high conflict child custody cases, so I understand why I got the question. Hopefully this video is useful to you guys. If you have any questions besides those that I've answered, please feel free to post them down in the comments below, and I will see you guys next time.